hold your questions until the end, and I'm going to go ahead and turn it over to Keith. Take it away. Thank you.
Thank you very, very much. I appreciate that. What we're going to talk about tonight, and this is going to be an informal presentation. We're going to talk about fair housing, which is really an overview of the Maryland Fair Housing Law. We are comparable to HUD housing law, though sometimes in states we have much broader housing laws, as even localities may have broader housing laws, but we can never be less than the federal. So my name is Keith Murkey. As Elena said, I am an education outreach associate with the commission, been there for 20 years. And so I want us to, so if you want to ask me questions, at the end, I'm going to make sure this PowerPoint is available. So you will have that. It also has our contact information as well. So this is where it doesn't want to go ahead again. All righty.
So just hover your mouse at the bottom of your screen on the left-hand side, and you should see some like little buttons pop up.
No, nothing's popping up.
Okay, well here, let me see. That is for me, and it doesn't want to do it. Do you see these buttons at the bottom left on the of your page? Like if you hover your mouse over it?
No, mine is full.
You have to be over the white part.
Oh, no, nothing's coming up. It's
Really?
Oh, let me, oh, there we go. Sometimes it just sticks. I'm sorry.
No, you're
All
fine.
right, so so we're right on. So the mission, our mission, you'll have a copy of this, so you don't need to memorize it. It is Maryland Commission on Civil Rights. We enforce Maryland's laws against discrimination, harassment in employment, public accommodations, housing, health services, and commercial non-discrimination. Health services was just added to our law in October, adding protections for any one of our protected classes from any kind of harassment or discrimination found in health services. And we're co-facilitators and co-enforcers with the Maryland Department of Health. And commercial non-discrimination deals with any company or business that is a subcontractor to the state of Maryland agencies. So we provide education and outreach services, and we want to promote and improve civil rights in the state of Maryland. So like I said, employment would include everything from how jobs are advertised, how the interview goes, including interview type questions, how you're treated at work with benefits, as well as if you're let go or you choose to leave. We will cover all of that if you feel that you're a victim of discrimination or harassment. Housing includes mortgage rates, it includes access to housing, it includes access to services or real estate agents. It even extends to if someone attacks you on your home and it's based in hate, so a hate crime would be a part of what we would look at. Public accommodations is access to any services or facilities that says we're open to the public, like public libraries, it's in its name. Hotels, motels, restaurants, community buildings, government buildings are open to public accommodations. And of course, health services I just mentioned, and commercial non-discrimination. So under housing, we have specific protected classes. Race, gender or sex. So under gender and sex, that would include gender discrimination if you're treated differently because of your gender, or if you are harassed through sexual harassment. So sexual harassment is where the Supreme Court identified sexual harassment was under gender discrimination. National origin, your religious tradition, which includes the entire spectrum. So from persons' religious beliefs all the way to their non-religious beliefs. Color, which is the tone of your skin. So it's kind of a misnomer. It's not like you're blue, green, or yellow. It is more like you're light or dark. So sometimes people get kind of caught up in that because they'll say, well, every person is of color. That's true, but we're talking about hue or tone. Your marital status, whether you're single, married, widowed, divorced. So that would fall under protection. Sexual orientation, which protects persons whether they are, and this is what the law says, whether they are heterosexual, bisexual, or homosexual, and it also includes perception of a person's orientation. We know that we would use more likely to use the terms like gay or straight, but or non-binary or non-gender conforming. So when we use these kind of terms, would fall into sexual orientation as well as gender identity, which I'll come to. Disability, which includes mental and physical. So mental would be learning disabilities, intellectual disabilities, mental illness, and physical are like sight, mobility, hearing, pregnancy, any kind of medical condition. And it's interesting that disability is the number one one of the major forms of discrimination in housing is disability. So that's something that you might want to remind, because it has to do with both modifications and accommodations in any kind of housing. Like I said, gender identity, and the definition of that is that it's any gender-related behavior, appearance, or caring of oneself, irregardless of a person's gender that were assigned at birth. So it is how we portray our gender, despite what we were identified at birth. Familial status, which is only found in housing, so familial status, I'm gonna talk a little bit more about, deals with the presence of children. It used to be called the presence of children law. And we have the new one, which is new this year, called source of income, and I'll talk a little bit more about that. But one of the things you notice that in housing, we do not protect age. Age is not a protected class because age has exemptions. So we've added 2 exemptions, 55 and older housing, 62 and older housing. And it was separated out so that familial status could be added. For a long time, many apartment complexes and facilities were going adult only. So children were not welcome in apartment complexes. It was very difficult for families with children to find housing. So that was that is what the legislator came up with as a compromise, was that we would add familial status but give age its own designations, 55 and older, 62 and older, and that's across the board. So some of the filing deadlines, this I'm always let people know. So any kind of complaint of employment or public accommodations discrimination must be filed within 6 months of the alleged unlawful incident. Or if it's harassment in employment, it's 2 years. That was expanded this year because we know harassment is very insidious and sometimes it takes a while for people to really maybe come to grips and maybe report it. So it takes much longer. For housing discrimination, it must be filed within 1 year of the alleged unlawful incident. So within 1 year. So if something happens and you're not sure, you can certainly always call us or contact us. And we can, through our intake office, and you could be walked through and see if it appears to be in some way, if it falls within our purview. So 1 year for housing. So our main functions at our office include intake, like I mentioned. They take the complaints, they assess whether it really falls within our purview, like in those protected classes, within the time limit. If it's assessed to be a complaint that might be valid, it's sent to the investigation department, who may have a traditional investigation or fact-finding conference. Litigation department, our legal department, are the ones that actually investigate, that will work with our investigators as they need, as well as representing our agency in any kind of litigation. The way they also work in the area of the legislature, so they work with any kind of new legislation that may be attached to our agency. And then, of course, in the unit that I'm in is the education and outreach unit, where we used to do a lot of outreach outside, and so that doesn't happen as much. But I mean, we used to, for example, come down to do festivals or things like that. And we still would love to do this. When we finally go back in person, we would still like to be up and going. We would go to the Easton Festival, the Easton Outreach Festival, and things like that. So all of those kind of things we do in outreach. But in education, we also do training, free programs. You can always check our website for the different kinds of things we do. So let's do a true or false. Fair housing predominantly deals with people who are renters. True or false? If you drop that in the chat, I don't have a chat, I'm sorry. So Elena?
I'm gonna guess, oof, I'm gonna go false.
Okay, false. Fair housing includes the entire arena of housing. So that could be, it could deal with sellers, it could deal with real estate agents, it could deal with advertising. So it's really, a lot of times people think of renters and being mistreated as a tenant. But fair housing is, it could be mortgage lending, which we've seen a lot of predatory lending early, back about, that really came to the forefront about, say, 13, 14 years ago, and it came out. And the number of houses that became underwater because of predatory lending in certain areas and to specific people. We need to remember that. So the key is sometimes we see things and we don't know what they mean. So this symbol, we see this, whether it's in print ads, we might see it on signs and things like that. That is the fair housing symbol. So not only do landlords, but banks, real estate agents, and anybody else that's in the area of housing use it to show that they will not discriminate against you or your family when looking for a home. When people ask, I have a friend that's in the, does ads, and he's always had to remind people, we need to put that in there because you want people to know that you're an equal housing opportunity, that you are not, you're not in the business of discriminating. So what is fair housing? You and your family have equal opportunity to choose where to live without being discriminated against or treated differently based on our protected classes. So equal opportunity to choose where to live within your monetary means. So sometimes people like, well, I mean, if someone doesn't have the money to buy a $25 million house, they don't have the money to buy a $25 million house. But when someone wants to see a $25 million house, and they can afford to buy a $25 million house, but the real estate agent says, oh, you don't want to live in that neighborhood because you wouldn't really fit in. That's when it said it has nothing to do with your money. It has to do with the group you're in. And that is where we start seeing the discrimination. So we're going to look at unlawful discriminatory practices. We're going to look at those protected classes again. We're going to talk about persons with disabilities as well as sexual harassment. Then I'll give you some resources. Another true false. An apartment complex can require that families with children must be placed in apartments on the lower floors of their buildings. True or false?
That feels false to me.
I like that. That feels false. It is false. Many times, this is the way that apartment complexes may kind of limit the number of families with children. So if all the lower floors of the buildings are already occupied and someone comes in with children, even though they've got 10 other apartments open, they'll be like, I'm sorry, but we only put them on lower floors and we're not able to accommodate you. The fact is they may use the excuse that it's because it's for safety for children, lower floors are safer for children. But the question that I've always asked is, who's responsible for the safety of your children? You are. So it's not the job of the complex or the apartment owner to protect your child. That is your job. If it's unsafe conditions like the railings are not nailed well or they're not attached or whatever and children fall, then it is your problem. But we're talking about people using things as an excuse, not a reason, but an excuse for it. So some of the unlawful discriminatory practices. Denying or refusing to rent. And this happens more often than you think, where people will say, no, I'm sorry, that's already been rented. So that goes in, or people saying to a real estate agent, don't show my house to a specific group. So denying or refusing to sell. Treating applicants differently. If you treat them differently in any kind of terms or conditions of the real estate transaction. If you advertise illegal preferences. I don't know if, I'm older, so I remember ads for apartments that used to say single white Christian wanted to rent room, or no children, or women only. Kind of preferences, and that's illegal. That's advertising your illegal preference. Some of the others. Providing false information about the availability of an apartment or a condo or any facility. And so if they lie to you and say, oh, I'm sorry, we've already sold it and it has not been sold, or we've already rented that apartment and it has not, that is an unlawful discriminatory practice, and they can file a complaint against you for that. Harassing or intimidating people from exercising their rights within fair housing. So if you use scare tactics to keep people from buying in a neighborhood, or threatening people, they've moved into an apartment, you threaten them, so people are afraid to leave their apartment, things like that also falls within our law as well and being illegal. Blockbusting, where you try to break up neighborhoods by telling people, oh, you better sell your house because this group of people is moving in. That was tried on me in my hometown. My neighborhood had 3 houses in it. And one of an older lady was moving out, and these people appeared at my parents' door and said, you know, you've got to fight this because you don't want an African-American, they didn't use the word African-American, of course, in the 70s, to move in next door or destroy your neighborhood. So, but we'll be willing to buy your house and your other neighbor's house. And my mother said, you know who I want living across the street? Someone who's quiet and someone who mows their yard. That's all I care. So millions of people are trying to block bust by doing that. Imposing different terms of financing because of a particular class. So there have been loan companies that have charged women and people of color a higher interest rate, and that's without even looking at their credit. So those different terms of financing, kind of funneling them to really very dangerous loan products, is what we were seeing when the predatory lending, focusing very specific, even if they qualified for a conventional loan, they still kind of focused them toward that, and that was specifically done to African Americans. Denying or applying different terms for the real estate services, such as brokering or multiple listing, et cetera. So either not allowing it, or just, you know, say, oh, we're going to have to pay an extra little fee for that, when otherwise you don't charge a fee. So protected classes. So I told you, federal law, there's a federal law which protects race, color, religion, sex, they use the term handicap, we do not, but handicap, familial status, and national origin. Now, under sex, the new HUD rules have now changed under the Biden administration, which will then say that under sex discrimination, housing, sexual orientation, and gender identity will fall within their being able to access the law, so that it's not separated like ours is as sexual orientation, gender identity, but it will be investigated under sex discrimination. So we have all of those 7, but we have added 4 more. So marital status, sexual orientation, gender identity, and source of income. Now there may be local laws, not said about Worcester County. I'm not real sure about that. I know that some areas have much higher, for example, Howard or Prince George's or Montgomery County, even Baltimore City may protect occupation, your political affiliation, your personal appearance, even veteran status might fall in there. So the political affiliation may fall within some of those as well. But for the state, it's the 7 with the federal, and there are extra 4 altogether for us. So let's talk about families with children. So we have parents or persons with legal custody of children under 18 living with the parent. So if someone has legal custody of children under 18, you're considered a family. Or children with a designee by the state or local law. So it may be someone, maybe foster care, et cetera, any multiple ways that that may be discussed. Person who's pregnant or getting custody of a child under 18. So the exemptions I mentioned, if it's housing that's solely occupied, it's 62 or older. So everybody in that unit must be 62 or older. No, there's no exceptions. The second group is 55 and older. So 80% of the units must be occupied by someone 55 or older. At least one person of 55 or older. The reason this was put in there is because thinking about the ages of people. So when you're 55, you might be married just like a 51-year-old, right? If you're married in a relationship, you're 51, the 55-year-old dies. All of a sudden, the persons in that unit are no longer 55 or older. So that 80% was given that 20% that someone under 55 could live there. The thing was 62 and older, so the person that is the youngest must be at least 62 in order to make sure that they are going to be solely occupied by 62 or older. And we've run into cases where, for example, a grandparent had to take in the care of their children because their child dies, and so the grandchildren must come live with the grandmother. They cannot live in 62 or older housing. They would have to move because of the designation by both federal and state as 62 or older. And of course, there's collateral issues. Sometimes in occupancy standards, landlords will say, oh no, you've got to have a separate bedroom for every single child. And sometimes they mix up occupancy standards for like foster care that might say you must have a separate bedroom for a female child and a male child. When it comes to your own family, that is not the case. So when we talk about source of income, the big issue has always been like, what if it's illegal? So the first thing it says is an income is any lawful source of money paid directly or indirectly to or on behalf of a renter or buyer of housing. So lawful is the first word I want us to focus on. So lawful profession or occupation or job, any government or private assistance, grant, loan, rental assistance program, which includes low-income housing assistance certificates, Section 8 vouchers, they are all legal forms of money. A voucher or certificate is a legal form, and so cannot be denied access to housing because of that, because they'll say we don't accept that. A gift, an inheritance, a pension, an annuity, alimony, child support, or any other consideration or benefit. And it may include also if you're selling or pledge a property or an interest in property. Say, for example, you and a sibling just inherited your parents' house and you're going to sell the house and split the profits. So you're waiting to sell the house. Well, that is a pledge of property or sale or pledge of sale, you know, that money is going to come from that. So that's one of the big things. It's a lawful source of money, so it's not an illegal source. Like the person can either pay you directly or it can come indirectly from another source, like a government, a grant, or loan, and it's done on behalf of the renter or buyer of a housing. So the exemptions is owner occupied, meaning if you are living in the, if you're living in the home and say, for example, you're renting 2 apartments out of your house, that is an exemption from that, as well as owner of 5 units or less. Those are the exemptions to this law. So owner occupied if you live in the building and you're an owner of 5 units or less. So large apartment complexes are not 5 units or less. So they will fall within it. Condos will fall within that as well. So continue with the exemption. So it is an exempt if it's sold without. So if you're selling your single family dwelling, you're exempt. But if you use any sale or rental facilities or services, such as real estate brokers or agents, any kind of salesperson, a person in the business of selling or renting dwellings, or an agent of a person in the business of selling or renting dwellings. And if you publish, post, or mail after any notice of any advertisement or written notice in violation of the subject article. So if you advertise your illegal intent, you are no longer exempt. So you cannot advertise it. If you don't use, if you use any of the rental services and you post it, your exemptions would become null and void. To be exempt, you can't use services and you can't advertise your illegal intent by focusing on a specific group. But it does not prohibit a person from determining the ability of a buyer or renter to pay a purchase price or pay rent, because you're allowed to verify in a commercially reasonable and non-discriminatory manner the source and amount of income or creditworthiness of a potential buyer or renter. So if you're checking the credit of all persons that are potential buyers or renters, and you use that which is available in a non-discriminatory manner, meaning you do it for everybody, you're going to be okay. Or if you prevent a person from refusing to consider income from criminal activity. So you do not have to consider income derived from criminal activity. Or prohibit a person from determining, in accordance with applicable federal and state laws, the ability of a potential buyer to repay a mortgage loan. So if you use an applicable state or federal laws to check on the ability of a person to repay a mortgage loan, you're allowed to do that. We don't prohibit people from doing that. It's when the problem runs in when we check it on some people and not others. And so that becomes that unequal kind of treatment. It starts to weigh. True or false? It is illegal to deny the rental of an apartment to persons because they are unmarried. True or false?
That is true.
True. Good. Great, Elena. Got it going there. It is illegal, and we must remember that, because so many times people's like, oh, I don't, and this happened a lot. My parents, actually in the 50s, my mother had been divorced and then married my father, and they couldn't find an apartment to rent because she was divorced. And the people would say because it was a sin, and technically they're not really married because my mother was married before. So that is no longer the case. That is illegal to do that. But it is illegal to deny somebody renting an apartment because people are unmarried. So we know that. We see people that are roommates that are renting places, but some people think they can deny that because of it. They want a married couple there. Sorry, but it's, it doesn't matter. So when we talk about persons with disabilities, now housing law is very, very complicated. It's also case by case. So many times someone may say that looks just like discrimination. Another person, then they'll say, no, it's not. So remembering this when we talk about any kind of cases is that it could be very complicated, and it on its face may look like blatant, and it may not be. So let's talk about disability discrimination. So it's unlawful to discriminate in sales because of a disability, such as make unavail or deny a dwelling, terms and conditions, just like everything, provision of services or facilities in connection with dwelling, and this is key. When we talk about sales or rentals, if there are other facilities attached to the dwelling, pools, pool houses, community buildings, those kind of things, that's a part of the provision of services and facilities. Or prohibition against, and it's a prohibition against inquiring about an individual's disability, and there'll be a caveat, I'll talk a little bit more about that. So a person with a disability, so a physical or mental disability which substantially limits one or more major life activities, which include things like mobility, deafness, blindness, mental illness, any one of those things that might cause, that limits one or more major life activities. And there are many major life activities. A person may have a record of such a disability. For example, people that may be considered alcoholic, they are not drinking, they're considered an alcoholic or recovering alcoholic, or they have a past drug addiction. That's a record of a disability. And could be regarded as being disabled. Now, I worked with people that were HIV, and many persons with HIV and AIDS would say, I'm not disabled, but there are people that might regard a person as as disabled, HIV positive, heart conditions, persons that had a history of strokes. They're being regarded as disabled, even though as they are now, they don't feel like they consider themselves disabled. So persons that aren't covered, juvenile offenders under our housing, under the housing code, sex offenders, current illegal drug users. Like I said, if you're recovering, you're protected. If you're a current illegal drug user, you're not protected. Persons who pose a threat to the health and safety of others, or they pose a threat of substantial physical damage to property. So those that are not covered by our law. There have been persons that have been evicted because they posed a threat to pose a threat to other persons, or posed a threat to the damage to the property substantial. So we're going to talk about two things, modification and accommodation. Real quickly, more about accommodation than about modification. But modification are physical things that we do to a property. So if someone has a disability, it's unlawful to refuse to permit at the expense of the person with a disability of an existing premises occupied to be occupied by the individual. So if someone says, look, I became disabled while in my apartment, so I'm going to need to lower the cabinets because I'm in a wheelchair and I can't access tall cabinets. The apartment complex must allow them to do that. Now, they also will require them to put it back when they leave. They may have to widen doors, widen a bathroom door, add grab bars in bathrooms, lower light switches, things like that. Many apartment complexes that have been built within the last 20 years, many times already start with that. If their builders and designers are ahead of the curve in recognizing this and knowing the law, they will make some of these adjustments already in some. And for a rental, the tenant agrees at the tenant's expense to restore the interior of the dwelling except for reasonable wear and tear. They're not going to ask you to bring the doors back. Like if you widen the doors for a wheelchair, they're probably not going to ask you to narrow the door again, because anybody can use that. And grab bars are the same thing. Anybody can use grab bars, but they may ask you to return the cabinets up, such as that, so that the next person in might not be a person that needs that modification. So reasonable accommodation, where modifications were the physical modification of the interior of a building. For example, accommodation has to do with rules, policy, practices, and service. So it's unlawful to refuse to make reasonable accommodation. So the word is reasonable. And so I always use an illustration like from employment. If someone needs a desk that needs to be higher because their wheelchair, for example, won't go under it, and they say, I see this great desk in the catalog, it's $2,500. Yes, that's a nice desk, but if the issue is it needs to be raised, we can put bricks under these desk legs, and it still does the same thing. So being reasonable about it. So we look at rules, policies, practices, services that are available. For example, some of the accommodations that are granted, these are things that have been granted through any kind of complaint system. Assigned accessible parking space. So if someone says, well, oh my gosh, but then everybody will want one. The person that came and asked for an accessible parking space is the one who asked. And we know there's limited to that. So it's first come, first serve. It's who you can make it for. You can't make every parking space that way. You may not be able to do that. But assigned accessible parking spaces have been granted. An exception to the rule requiring tenants to bring rent personally to the office, because there have been offices you have to bring in person the rent. You can't mail it, you must bring it in person. So an exception if someone cannot get out very much, or they don't leave their apartment very much. An exception to the no pet policy for emotionally disabled tenant, and we're going to talk more about that. So let's talk about assistance animals. And this is something that we're seeing more and more an issue, especially during COVID. There are persons, because we've seen the rise of more exacerbated mental illnesses and persons needing accommodations around especially assistance animals. So an assistance animal is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability. That what it does is alleviates one or more identified effects of a person's disability. An assistance animal is not a pet. So remember the last slide when it says there's an exception to the no pet policy or the no pet fee. The assistance animal is not a pet. Therefore, it is not a pet. So therefore, you don't need there is not a no pet issue about it. It's not a pet. It's an assistance animal. Some more. So there are types of assistance animals, and sometimes one of the things that always comes to our head first tends to be the first two. Hearing dogs, for example, they alert their handlers to important sounds. If someone, have a hearing impairment and they don't know when the doorbell rings, or an alarm, a fire alarm, someone pounding on the door, kind of thing, So those hearing alert dogs or guide dogs. And with this one, we may think more persons with a visual disability who might be using a cane as well as a guide dog. It helps those that are blind or visually impaired navigate safely streets, buildings, rooms, etc. But there are a couple more. So we have seizure alert animals that have been trained to let their handlers know if there's an impending seizure coming. And that might be let them by, whether it's by pressing against their body. They may also guard them if someone has a seizure and falls down. They may be the one that guides the person down, so the dog may lean against you. So if you start to go down, the dog will help you, or the animal will help you, guide you down, and then protect you. Psychiatric service animals helps handlers manage mental and emotional disabilities. What they might do is interrupt self-harming behaviors, reminding handlers to take medication, could be checking spaces for intruders or providing like that calming pressure during anxiety or panic. And I will speak that I have that in my family. And so their animals provide very calming pressure during a panic attack. And then allergen alert animals. This may be some of the people don't know about. It lets their animals know if there's foods or other substances that could be dangerous, such as peanuts. And someone may not see that, but if the allergen alert animal is trained to scent or smell peanut butter, whatever that is, it could be something else as well, and alert the handler to that, so they would not have an attack of an allergy. So some key points, and I keep reiterating this: they're not pets. I can't say it enough. Many times rental landlords will say, but I don't allow pets. They're not pets. They are assistance animals. It does include emotional support animals, which are those that provide comfort or safety. So many times people will say, well, I will allow a guide dog because they've known that for years. But oh no, I don't believe that animal, that's not allowed. They'll go into that. And it can be animals that are specifically trained or animals that do work and perform tasks for the person with a disability. I was just reading an article about a young man that had a spinal injury, and he had I hope I say it right because I'm not great with certain words, the capuchin, the little capuchin monkey. And because that monkey has very small hands, that monkey can turn on lights, can open water bottles, and can open doors. And so a dog would not be able to open a door necessarily, or open a bottle specifically, but that capuchin is trained for that. And so they're performing a task that their handler may not be able to do. So the Fair Housing Act requires a housing provider to allow reasonable accommodation involving an assistance animal in situations that meet the following conditions. You have to allow it if, one, the request was made to the housing provider by or for a person with a disability. So it doesn't have to be the person with a disability. It could be someone, it could be a medical professional, social service professional, a family member could ask for that person with a disability. And it's supported by reliable disability-related information. So if the disability and the disability-related need for the animal are not apparent, and the housing provider requests such, and they requested such information. So if it's not apparent, so if a person might have, let's say, a mental disability that is not quite apparent to the landlord, they might ask for some kind of documentation, whether it's from a medical professional or whatever, about not only maybe about the need for the person with a disability to have an animal, assistance animal, and maybe even that specific assistance animal, especially if it's not apparent, and you can request that. Now, you can't ask everything. So the housing provider has to demonstrate, if they haven't demonstrated that granting the request would impose an undue financial and administrative burden on the housing provider, like this is not other than, usual wear and tear, or the requests which fundamentally alter the essential nature of the housing provider's operations. For example, and I gave you one before, like you requesting you're requesting the landlord to provide transportation to the grocery store. They're not in the business of transportation, they're in housing. So that would fundamentally alter the essential nature. Or the specific essential animal question could pose a direct threat to the health or safety of others, no matter what other reasonable accommodations that could eliminate or reduce the threat. So if the it would pose a direct threat to the health or safety of others. The request would not result in significant physical damage to the property of others, despite any other reasonable accommodations that could eliminate or reduce the physical damage. You have to show that. So the housing provider must show that this is what's good, that none of this would happen, or they have to accommodate the assistance animal. So examples could include a request to live with an assistance animal at a property where a housing provider has a no pets policy. Right, so again, not a pet. Or even a request to waive a pet deposit fee or other rule as to an assistance animal. So once again, because it's not a pet, you may argue that therefore a pet deposit would not be a valid request. But there are some other accommodations that have been denied. So requests for daily trash pickup by a housing provider, like you can't, you put your garbage outside the door and ask them to pick it up, unless they're providing it as a part of a perk service for everybody in the area, that can be denied. Requests for the housing provider to walk a service dog. They're not in the business of walking your dog. Or request for provider to transport tenant to and from grocery store and do shopping. So as I mentioned that before, some places do. I know there's a large retirement home that does provide small bus service, but taken specifically to the mall, to Walmart, things like that, and they will pick them up. So they provide that. Not all places do. So when we talk about inquiries, a housing provider cannot ask if you don't need to ask or inquire about a disability when it's an obvious disability, except if that requested accommodation is not obvious. So someone has an obvious disability, say blindness, a visual, and they're asking for a service animal to do something other than guide or whatever. So unless it's obvious, if it's not obvious, you can inquire as to why do you have need of this specific animal? Why do you have need of this accommodation? You can ask that. But if it's an obvious disability, you don't need to ask. You could inquire into the severity of a disability to assess an applicant for housing limited to persons with disabilities. So if you are running housing for persons with a disability, you might have to assess the severity of a disability in order to make sure they can access that, so that applicant can access it. And it really is restricted to threshold questions. You're not allowed to ask all the deep, dark, dirty, whatever people want to tell you about their disability. You ask threshold questions like how would your accommodation need, what is the connection between your disability and the accommodation need? What is the connection between your modification request? You can only ask threshold questions. You can't ask them all the details about their disability, if they became disabled, how they became disabled, all of these kind of questions that people just want to know, but you're restricted. So the last little section I want to talk about is sexual harassment, because we've seen that in the forefront in employment, people coming forth after years. But sexual harassment is really quite prevalent in housing as well. So it is unwelcome sexual advances, both verbal and physical conduct that's directed toward individuals such as a tenant. So there are two types of sexual harassment in housing. It follows along with employment, but we're going to talk about specific housing: quid pro quo and hostile environment. So quid pro quo means someone has power over someone else. Quid pro quo, therefore, has to have someone that controls some part of a tenant's life. When a housing provider or his or her employee, agent, or contractor, so that includes maintenance, it includes persons that may be just working in the office, etc., conditions access to or retention of housing or housing-related services or transactions on a victim's submission to sexual conduct. We saw this happen in housing authorities where maintenance workers would withhold repairs unless, for example, a female would sleep with them or do any sexual favors. This happened in Baltimore City. It happened in other counties, in other cities and counties as well. So they submit to it or they're not going to get repairs. Or during COVID, things like, I know you're not able to pay the rent, so maybe you can work the rent off, or I'll reduce the rent. So those are some of those things. So those are the kind of things with quid pro quo. Someone has to be able to control, your rent, control your access to services. Hostile environment's a little different. It's when a housing provider or his or her employee, agent, or contract, so it includes them, or in some circumstances, another tenant engages in sexual behavior that have such severity and pervasiveness that it alters the very terms and conditions of tenancy and results in an environment that is intimidating, hostile, offensive, or otherwise significantly less desirable. So your home, which is supposed to be a place that you feel safe and protected, becomes unsafe. And I always tell people, think about this. For example, a maintenance person is going to have a key to your apartment. When you have persons that are entering without letting you know, entering your premises while you're there, making some kind of sexual advances or sexual banter even, creating that environment that you feel so unsafe and it's so offensive and it intimidates you, that is hostile environment sexual harassment. So it could be another tenant. So it's another tenant that constantly is right outside your door, talking the talk, and you just want, so you get out of your car and you look to make sure they're nowhere around, and then you run for your apartment. It doesn't make for an easy living into your apartment. You don't use outside things, you're afraid to go out. So it could be a tenant, it could be the housing provider, or any of those employees as well. It might even include people like vendors, people that are coming to say, in the office, they fill a soda machine, and then those kind of things may come up to play as well. So I want to give you 3 resources beside ours, so you'll have ours as well, but 3 within the state of Maryland. You have the Fair Housing Action Center, which has kind of risen from the ashes of B&I, which was the housing tenant, the landlord-tenant kind of organization. They work in hands with us as well. The Maryland Department of Housing and Community Development also is one of our state departments of housing specific, as well as legal aid for people that might not, may need assistance in maybe pursuing something. For us, if you bring a complaint with us, it does not cost you anything, but technically we're not your lawyer. We are going to sue on behalf of the state if we take it as a case, because they are breaking state law. But some persons may want to have legal representation, and they may not. So they may actually be able to ask Maryland Legal Aid some questions, and they may be able to access their services as best they can. Do you have any questions?
I'm going to go ahead and unmute.
Okay.
Here, so if they want, they can. Anybody who wants to can talk. You just have to unmute the microphone. If you're on a lap or desktop, it's at the bottom left of your screen.
Okay.
I see a person on the phone. Hi, person on the phone. Did you have a question? Oh, no, they don't have a question.
Okay.
I guess I have a question. I mean, 2 parts. How pervasive is this discrimination, and how difficult is it to win these cases? Well,
one of the things is that people don't report a lot of housing cases because having your home is so important to you, and if you're retaliated against for filing it and you lose your home, you're impacting a lot of different lives. So sometimes people don't file because they're terrified.
Yeah.
It's where they live. It's easier many times to find a new job than it is to find a new place to live. And we know in this tight market, that could be true. Or accessing services such as multiple listing and all that, even when you're buying. If someone doesn't allow you to use that, it makes it difficult to sell a house or purchase a house. I've always believed that for everyone that we get, there's probably 5 that are not filed. And so we're starting to see a little bit more. I think more is going to happen as we start seeing larger numbers of the mass evictions. You know, as people aren't able to pay, it's been on hold. You're been on hold, but all of a sudden they say, now you owe us $14,000.
Yeah.
And so it may be when the moratorium is lifted, we're going to have some issues. But it is found in every county. It's found in every city. People are learning many times how to get around, you know, what's illegal by using, you know, not using the right word. You know, they'll use other words. We don't think you'd be happy in this neighborhood. That happened to me in Baltimore City, a real estate agent. I said, I can afford that house. I like the look of it. Can you show it to me? She says, no, I can't because I like you too much. I can't show you that neighborhood. That's called steering, people.
That's great.
Instead of what they should have said was, Keith, why don't you drive by there in the morning, in the afternoon, in the evening, check out the neighborhood, and then let me know if you want me to look at the house. Because then it still becomes my choice. But I'm an adult. Don't make the choice for me. You know, don't make that choice for me.
Absolutely.
So, and that's, you know, that's a reality. I think we're back up to 4 again.
Yes, the phone call is back. Does anybody else have any questions before we call it an evening? Libraries are very concerned about the moratorium being lifted as well. So if anybody is looking for a starting place, we can't help you with housing rates or legal aid, but we can point you in the right direction. We can get you to resources and information.
Great, wonderful.
Yeah, we do care about the community. That's why we're here. And so we will certainly help anybody get to the proper resource. So Thank you so much for being here. This is a lot of information and a lot of incredibly important information. And this will be posted on Worcester County Library YouTube channel. So people,
wonderful.
And they'll be able to see the slides and everything.
Yay.
Yay. All right. Well, I thank you all for being here, and everybody have a good summer evening out there.
Yes, you too. Thank you, Elaine.
Right. Bye.
Bye. Take care.
You too.